At age 39, Samuela Sirivakawa moved from Fiji to Australia. He was a teacher in Fiji, and obviously not being able to become a teacher straight away in Australia, he elected to do other jobs while he was here working on other things. He went and he got a job working as a trainee groundsman. He had less than 7 days' experience when the following incident happened. On the 7th of September 2019, Samuela attended the Cromhurst School in Sydney at 7:30 in the morning to help his employer, A1 Arbitrary Services Proprietary Limited, with the disposal of trees at the school. It was a school day with children in attendance. The boss of the operation, Mr. Saunders, gave verbal instructions to the workers. Samuela was tasked with helping a colleague, who I will refer to as JW, remove trees along Koshia Lane. JW and Samuela worked together, stacking branches and logs from trees being cut by Mr. Saunders in a pile, ready to be chipped. Once enough wood was gathered, JW and Samuela started hand-feeding them into a Bush Bandit whole tree wood chipper, model 2090. Both Mr. Saunders and the company knew of serious safety defects with the machine dating back to 2016. The company A1 did not have a mechanical log loader or other apparatus on site to feed the branches and logs through the wood chipper. The company A1 did not conduct a daily startup check of the wood chipper prior to the commencement of its use. As at the date of the incident, the wood chipper was not fitted with a feed wheel control bar. This meant that workers needed to reach over the infeed tray to activate the forward and reverse control mechanism. JW and Samuela started hand-feeding branches and logs through the wood chipper. Mr. Saunders asked JW to go and talk to a member of the public on a footpath about a trivial parking issue, leaving Samuela alone with the wood chipper. Court records suggest Samuela was alone for about 10 to 15 minutes. As JW returned to the site, Mr. Saunders asked where Samuela was. JW replied he did not know and thought that Samuela may have gone to the toilet. Not waiting for Samuela to return, JW proceeded to finish the task and started hand-feeding the wood chipper alone. This took 20 to 30 minutes. Shortly after finishing the task, the two other workers on site returned to the truck and wood chipper and asked where Samuela was. One of the workers noticed blood spattered across the back of the truck and the front of the wood chipper. New South Wales police were called and attended approximately 20 minutes later. It was apparent that Samuela had been drawn into the infeed hopper of the wood chipper, passed through the feed rollers and into the chipper disc drum and sustained fatal injuries. Sadly, this isn't a training hypothetical. I'm talking about the case of SafeWork New South Wales versus A1 Arbitrary Services Proprietary Limited and another, the other being Mr. Saunders. This was a case that was decided only about 2 weeks ago in the New South Wales District Court, and this case has set the highest penalty recorded against a company so far. My name is Daniel Patterson. I'm a registered work health and safety officer with Northern Rivers Workplace Health and Safety. What I have just read out is an abridged version of the fact sheet that was tendered by the prosecutor in court. So charges were filed against both A1 Arbitrary Services Proprietary Limited, the company, and Tony Saunders, who is, for all intents and purposes, the owner. He ran an arborist company before A1 Arbitrary Services and liquidated it, and then they started A1 Arbor, which his wife is technically the director of. A1 Arbor were charged with a Category 1 work health and safety crime. It is the most serious crime that exists in New South Wales with regards to work health and safety. It is found in Section 31 of the Work Health and Safety Act 2011, and the maximum penalty for a corporate defendant is a $3 million fine. Tony Saunders was charged with a Category 2 work health and safety crime. It is the most common crime to be prosecuted before the district court with regards to work health and safety, and the maximum penalty for an individual defendant, that is someone who is not a company or not a business, is $150,000. So in criminal law, you have what are called elements of a crime, and sometimes you only need to prove one or two elements. Sometimes you might need to prove a dozen elements. But with the case of a Category 1 offence, there's really only three to prove. You need to prove that A1 had a health and safety duty. You need to prove that A1 engaged in conduct which exposes a person they have a duty for to the risk of death, serious injury, or illness. And you also need to prove that they engaged in the conduct with recklessness or with gross negligence. If you can't prove all three, then usually you have to go for lower charges or drop the case altogether. But obviously, as they were convicted, we're going to talk about what they did that enabled the prosecutor to prove all three elements here. So, when prosecuting Mr. Saunders for his crimes, they had to prove that Mr. Saunders had a health and safety duty, that Mr. Saunders failed to comply with his health and safety duty, and that Mr. Saunders' failure exposed individuals to a risk of death or serious injury or illness. It's similar to what they had to prove against the company, but they do not have to prove gross negligence or recklessness in this matter. So all they have to prove is that you were meant to do something, you didn't do something, and as a result, someone died, could have died, or did or could have got a serious illness or injury. It's a pretty common charge. The only one below that is a Category 3 offence, which is just that you had a duty not to do something unsafe and you did something unsafe, but you did not expose anyone to a risk of injury or death. So the elements of gross negligence and recklessness are cited in Section 31 of the Work Health and Safety Act, and these are very fluid definitions. There's no set definition of this level of misconduct is reckless, but this level of misconduct is not reckless. It is something that the judge basically has to be satisfied of, and it has to be proven beyond reasonable doubt. So here you can see the Criminal Trials Court Bench Book released by the Judicial Commission of New South Wales 4-080. And this is basically the most simple instruction I could find in that part of the book. And that is what a judge is meant to consider with an element of recklessness. It doesn't perfectly fit work health and safety law, but it's sort of the best definition I could find in the book. And that is how a judge would decide recklessness. So it is a very complex issue to decide recklessness and whether or not it did occur. That's why usually they don't charge Section 31. They go with Section 32, where they don't need to prove recklessness. But in this case, you can absolutely establish that any reasonable person would have known that they were sending someone more or less to the risk of death or serious harm, and they just did not care. They didn't actually do anything to prevent it. So that, I think, is why the prosecutor did go forward and pursue a Category 1 charge, and they were successful. They did successfully convict the accused. So, yes, I just thought I'd touch on that before we move on. Recklessness is a very, very difficult element to prove, and that is basically what a judge is meant to look at for proving recklessness. So, this is not a picture of the exact wood chipper, but it is the exact same model that was used to kill Samuela. This wood chipper was purchased around about April 2015 by the defendants, which was A1 arborists. Now, this one was serviced regularly by a company called Bandit Tree Equipment, and they're the Australian importer of the Bandit wood chipper line. Now, they serviced these between 2015 and 2024, the defendant, A1, and this wood chipper, as you can see from the picture, it's a large thing. You're not going to go and get one of these at your local Kennards hire. It's a whole tree chipper. It's meant to take a whole tree through it and turn it into a pile of mulch. It's not designed to be fed by hand. It's designed to be operated by two experienced operators and be loaded mechanically. As you can see from the picture, I believe that is a log loader. I'm not an arborist, so I don't know all the industry vernacular, but that looks like what I would call a log loader at the back of the machine holding that branch and feeding it through. That way, there's zero risk of a human's hand going in because they shouldn't have their hands anywhere near the intake. And that has stickers all over the back of it that says, do not feed by hand. So then you can start to see where the element of the offence against Mr. Saunders was proven. He's given them the instruction to go and load it by hand, and with more than 30 years' experience in the industry, he ought reasonably know it's not meant to be loaded by hand, and he's therefore asked them to do something that he should know could put them at the very real risk of serious injury or death. So at the time the machine was sold to the defendant, A1 Arbor Services, the wood chipper had three primary safety features: emergency stop buttons located on either side of the machine, a feed control bar which controls the forward or reverse direction of the rollers, and a hydraulic control valve that immediately stops the feed rollers. So a feed control bar is basically a primary safety device installed on wood chippers to protect the operators. When it's pushed forward, the bar reverses, and basically whatever was getting pulled into the wood chipper comes back out. In a neutral position, the rollers just don't turn, and when the bar is pulled back, the rollers would draw material into the machine. In case of an emergency, the feed control bar could be pushed by the operator or a bystander, which would reverse the rollers. It's basically in a perfect position on almost every machine, where if your arm's getting pulled in, it's too late for your arm, but the rest of you doesn't have to go in. You can push that bar and it'll spit your arm back out, or whatever's left of your arm back out. It's an important feature in circumstances where a person is being drawn into the in-feed hopper. You can imagine you might not have the presence of mind to reach around to the side and hit an emergency stop, and you might not even be able to do that. The absence of a feed control bar meant that workers would need to reach across the in-feed tray to use the control mechanism or to try and hit one of the e-stops. The worst part about this, and just showing the absolute callousness of the offending by the people involved here, at all times, this could have been fitted by BTE in about a day or less for 2,000 plus GST, so $2,200. For want of $2,200 of maintenance, there is now a worker dead. And the more facts that were dug up by the prosecutors didn't really help the defendants in any way. In February 2016, Mr. Saunders, and by proxy A1, became aware of the issues with the feed control bar. Basically, the thing wasn't working properly. When they were notified about it by BTE, the company that does the maintenance, they were told by BTE it was unsafe to use and the feed control bar was needed so that the feed wheels could be reversed in any emergency situation. That is a quote directly lifted from an email from the service manager to the company. So as I realize this video is getting a bit longer, I'll try to just speed through it here. The systems of work are piss poor, to use a technical term. They did not really have anything outlined. There weren't really any swims developed for the work that was being done. There weren't any pre-starts. There were never any toolbox talks. There was nothing that sort of encouraged safety in any way, shape, or form. So systems of work are definitely a contributing factor when you are prosecuting a health and safety violation, because if someone gets injured, but there's ordinarily really, really good systems of work, you might actually go very lenient or consider lesser charges because it was more than likely just an accident. But in cases like this, it actually serves as more of an aggravating factor that everyone knows these days. The Work Health and Safety Act has been in place since 2011. We know safety's being taken more seriously. We know regulators are being given more powers, yet they don't go through and actually develop a safe system of work or follow the laws that they are meant to. So, in this case, I imagine that's why the prosecutor went after them as hard as they did, because it just shows they did not care or think about what would happen if X, Y, and Z happened and a worker died. So, in all criminal matters, a judge would be considering at least four things. Number one, he'd be considering the objective seriousness of the offence. So, in this case, I'd absolutely conclude that the offence is objectively serious. It was foreseeable harm or risk, and the steps available to avoid the risk were straightforward and available to the defendants. I mean, one of those steps would have cost $2,200. Another step would have been use the proper tools for the job. So it is a very serious offence, and there's really no excuse for the offending. Then deterrence. So in criminal law, you have to consider two things for deterrence. You have to consider specific deterrence, which is this penalty going to teach this person a lesson and have them not do it again? Sometimes the only deterrence needed is something looming over their head, something like a 2-year good behavior bond. This is for someone who hasn't really committed any serious crimes, or it's their first offence and they're not likely to reoffend. Then you have matters where this person's done the same thing 5 times, they need to go to prison. But in this case, because prison's not an option for both defendants, then the element of specific deterrence would basically be give them the maximum fine. You also would have general deterrence, which is this going to teach the community a lesson? So we all hear about general deterrence every day when we read the newspapers that a person robbed a bank and got 14 years in prison. Well, that means that you're not likely to rob a bank because you don't want to spend 14 years in prison. So that's another thing that a judge must consider. And then aggravating and mitigating factors. So in this case, the defendant entered a plea of guilty very early. Now, that could have been because they knew that there was no defense, but at the very least, it does show some remorse. They know that they did the wrong thing. They know the accusations against them were true, so they weren't going to fight it because they were absolutely guilty of what they were accused of. Now, a plea of guilty is usually interpreted by a judge to indicate some remorse. They did, however, attempt to blame the victim for his own death repeatedly throughout the hearing, and that didn't work. Then they switched tactics and tried to claim that he might have committed suicide, which, trust me, there's better ways to go than put yourself through a wood chipper, and that also didn't work. So there really is no goodwill in sentencing when you've shown some remorse, but then you've turned around and basically insulted the victim and refused to take responsibility for your actions. So aggravating and mitigating factors are definitely something that the judge would absolutely have considered in this case. Now, if a judge is going to impose a fine, they also must consider the capacity to pay. So someone like me, you give me as an individual a $3 million fine, I can't pay that. It's not reasonable. Even if your job is to try and deter people, you know that I can never pay that. Now, the objective seriousness of the offence is definitely something where, unless there's any reason not to give them the maximum, you're going to give them the maximum. And I think I'll leave it for the judge themselves to have the last word when it comes to how they decided sentencing. Usually, district court judges like to give a good rationale or a good reason for their sentence before they give it. And prior to sentencing, this is what was said by Judge Strathty, who was the judge presiding over this matter. The objective seriousness of the offence is such that it must be reflected in a significant fine. I am uncertain whether the defendant is likely to reoffend, but the seriousness of the offence is such that a fine must be imposed to send a message to employers that they must take their obligations to protect their workers from a risk of injury very seriously. To reduce the fine significantly would not provide the level of general deterrence that is expected, nor specific deterrence, given the risk that Mr. Siravakayawa and other workers were exposed to. So, as for the sentencing of A1 arbitrary services, a conviction was recorded for a Category 1 offence. A $3 million fine was imposed. With the consent of the prosecutor and a bit of judicial discretion, the fine was lowered to $2,025,000. Now, with regards to the sentencing of Tony Saunders, a conviction was recorded for a Category 2 offence, a $150,000 fine was imposed, and with the consent of the prosecutor and further judicial discretion, the fine was lowered to $112,500. So, really, like most prosecutions, you don't see immediate results. It only was today that SafeWork released their big public statement and their bulletin about this case. It's been about 3 weeks since the decision, so it's going to take some time. Usually, you've got 28 days to appeal it. It doesn't look like an appeal has been lodged, so I don't think they will be appealing this decision. I don't see what grounds they could appeal on to begin with. So it's not going to really change anything immediately. Now, the overarching department for safe work, they do get to keep half of the fine amount. So they'll be getting a good $1 million coming their way, and I hope they spend that on community education and helping arborists maintain compliance with the Act. A registration scheme or licensing scheme with arborists has been suggested many times since the 80s and 90s, all the way through to now. It's never happened. So we will see. We'll see if maybe this is the event that leads to arborists becoming a trained profession that is registered, that is accountable, just like a builder or someone like that. I don't have high hopes, but it would be interesting to see. So thank you very much for coming and listening to this. And if you think I could do anything better, or if there's anything you think I should have spent more time covering, please let me know. This is my first sort of case law review. And please reach out to me by email if you have any questions or queries or suggestions. Thank you.